All right, thanks everyone for joining us for session 6.2 on Saturday. So we are joined by Matt Rimmer, who will be discussing or giving a presentation and followed by a discussion on AGL and Greenpeace, culture jamming, creative confrontation, and climate activism. So I'll pass over to Matt, who will introduce himself and give his presentation. Thank you so much for joining us, Matt.
Thank you very much, and thank you for the opportunity for talking about climate change, culture jamming, and climate activism. I've been working away for many years now on intellectual property and climate change, and I've been writing a manuscript looking at greenwashing, trademarks, consumer law, and internet domain names. And as part of that work, I have been looking at ways in which environmental and climate activists have been trying to use parody, satire, and other means of cultural critique to target companies who have been engaged in greenwashing. So my presentation today is really going to focus on the dispute between AGL and Greenpeace, which has kind of taken place in the past year. And I might kind of compare and contrast that to some other case studies that I've been looking at involving Greenpeace. But also I would observe that there's a more kind of general phenomena taking place here in which there are these clashes between fossil fuel companies and community-based activism, in which various different legal rights are invoked. In some ways, this is a very kind of long-standing area of interest of mine. So when I was doing my honours thesis back in the 1990s, I was looking at copyright law and parody and satire and postmodernism. So over 20 years later, it's kind of nice to kind of return to those kind of basic kind of themes. And intellectual property has often had a lot of difficulty with forms of mimicry that depend upon copying other work. But at QUT, really, I have a bit of a roving brief. I kind of do work across a whole wide range of different areas. I'm very interested in intellectual property and climate change. I've kind of written a book on the topic and edited a book on that topic. I'm trying to build up a large collection at the moment with some colleagues on intellectual property and sustainable development. But I also kind of roam freely across other areas. So I've done work on digital copyright, gene patents, access to essential medicines. The most influential thing I ever did was push for plain packaging of tobacco products, which involves stripping away advertising from tobacco companies' packaging. But I've been kind of interested in kind of larger questions around intellectual property and human rights for some time. As is always the case, I'd like to acknowledge the Turrbal and the Yugara, the First Nations owners of the lands where QUT now stands. We pay respect to their elders, laws, customs, and creation spirits. And we recognise that these lands have always been places of teaching, research, and learning. And QUT acknowledges the important role Aboriginal and Torres Strait Islander people play within the QUT community. And as I'll kind of mention later in my talk, one of the kind of key precedents in this field actually involves an Indigenous protester, Lou Davis, complaining about the bicentennial celebrations in 1988 and having the Bicentennial Authority try to bring action against him. That was a really kind of important precedent in which the High Court of Australia kind of talked about the importance of freedom of expression, particularly from dissenting voices and minority voices. And out of that kind of landmark decision evolved the notion of implied freedom of political communication in Australia. So although my talk is focused on AGL and Greenpeace, I do think there's some really kind of interesting dimensions there in terms of cultural critique and political communication by First Nations groups. Now, to begin with, I'd just like to say a little bit about Greenpeace and its long-term efforts to kind of battle greenwashing. Over a long period of time, the environmental organisation has sought to track the phenomenon of greenwashing and critique it. Greenpeace have commented that the term greenwashing has a long pedigree. Greenwashing took root in the 1970s when the growth of the environmental movement brought awareness of ecological damage to the general public. The practice was honed and perfected by professional public relations companies. Since then, the intensity and frequency of greenwashing waxes and wanes with the public and political mood of the times. This latest phase is no different than earlier cycles, except that the stakes are higher as global warming looms. So Greenpeace has identified a number of different varieties of greenwashing, and it's screed. It's kind of complained of dirty business, namely touting an environmental program or product, while the corporation's product or core business is inherently polluting or unsustainable. Greenpeace has been critical of ad bluster, using targeted advertising and public relations campaigns to exaggerate an environmental achievement in order to divert attention away from environmental problems, or if it spends more money advertising an environmental achievement than actually doing it. The organisation has been concerned about political spin, advertising or speaking about green commitments while lobbying against pending or current environmental laws and regulations. And finally, Greenpeace has been concerned about advertising or branding a product with environmental achievements that are already required or mandated by existing laws. And Greenpeace has used a number of different strategies to counteract greenwashing. Sometimes they've made legal complaints, so they brought actions under consumer law alleging that there's misleading and deceptive conduct. Sometimes they've engaged in creative confrontations. The head of Greenpeace Australia Pacific, David Ritter, has kind of spoken about the role of law in environmental advocacy. He contended that there are legitimate forms of civil disobedience to progress law and policy towards addressing climate change. Quoting John Rawls, Ritter argued that civil disobedience is a public, non-violent and conscientious breach of law taken with the aim of bringing about a change of law or government policies. He commented that civil disobedience forms a precious part of Australia's democratic heritage. Ritter added that Greenpeace has long been part of this heritage. He has called on lawyers and law students to assist the environmental movement. We need you fighting for law reform. We need you searching the common law for useful concepts. We need your very generous offers of pro bono assistance. We need you providing legal support to activists and campaigners. We need defenders of civil disobedience. And we need you agitating the idea that a legal system that permits this to occur is necessarily experiencing a crisis of its own legitimacy. As an illustration of Greenpeace's creative confrontations over greenwashing, this particular paper today provides a case study of the intellectual property dispute between AGL and Greenpeace. I want to tell you a little bit about the facts of the dispute. I want to kind of explore some of the copyright dimensions of the conflict. I'd like to kind of look at some of the questions around trademark law. And then finally, I'd like to kind of investigate questions about public participation, freedom of speech, and so-called SLAP lawsuits, strategic litigation against public participation. So to begin with, in May 2021, this year, Greenpeace released a report on AGL called Coal-Faced, exposing AGL as Australia's biggest climate polluter. This report engaged in a critical review of the advertising and promotional campaign of AGL. It said the company's publicity material makes it seem like most of the energy and money it generates comes from renewable energy power sources like wind, hydro and solar. Indeed, the company proudly advertises itself to the Australian public as green and environmentally responsible. It boasts that it is the biggest ASX listed investor in renewable energy and insists that it is helping to shape a sustainable energy future for Australia and has a relentless determination to improve the planet. The report by Greenpeace argued that a deeper dive into AGL reveals that the truth about the company is very different to its carefully crafted public image. This report argues that there was a disjuncture between AGL's marketing and its actual climate emissions. It said AGL is in fact Australia's biggest domestic contributor to climate change. In 2019 to 2020, it was responsible for over 42 million tonnes of greenhouse gas emissions. This was more than 8% of Australia's total emissions and more than twice the amount of the next biggest emitter of greenhouse gases. The primary reason for AGL's huge amount of emissions is that despite advertising itself as a hero for the environment, AGL is actually a hero for fossil fuels, and in particular coal. Greenpeace noted that AGL currently owns 3 aging coal burning power stations in Victoria and New South Wales. Moreover, they kind of represented over a quarter of Australia's coal power station capacity, more than double the carbon of the second biggest electricity generator, and more than BHP, Rio, Glencore and Qantas combined. The report commented that by keeping coal burning power stations running for almost another 3 decades, AGL is also acting in contrast to some of its major competitors in the Australian electricity sector. The report also kind of noted that, the continued rise of clean energy is inevitable. It's not a question of if, but when Australia will be powered entirely by renewables. The executive summary pleaded as Australia's biggest polluter, AGL can lead the way in this transition to a clean, sustainable future. But it observed that the company was really heading in an opposite direction. By committing to keeping burning coal until 2048 instead of exiting it before 2030, AGL is both jeopardising human and planetary health. And moreover, Greenpeace warned that AGL was also jeopardising its own financial position, given the 3 coal burning power stations it owns are unlikely to remain profitable over the next decade. The report did kind of carry a disclaimer. It noted, while this report does not suggest any illegal conduct on the part of any of the individuals or organisations named, it shows that AGL is currently using its position and power to slow the transition to a low carbon economy, which is jeopardising both human and planetary health. Perhaps that disclaimer there was really making sure that they weren't exposed or vulnerable to any action in relation to defamation law. In addition to this kind of analytical report, Greenpeace developed a creative culture jamming advertising campaign in respect of its work on AGL. The head of communications, Nellie Stevenson, explained the advertising campaign entitled AGL, Australia's Greatest Liability. Nellie kind of noted, for years, AGL has been trying to pull the wool over our eyes to hide its dirty and climate-wrecking coal operations, masquerading as a renewables leader when 85% of the power it generates comes from dirty coal. So Greenpeace said that its advertising campaign was intended to inoculate Australian consumers and citizens against greenwashing by AGL, and it was also intended to highlight the gap between AGL's rhetoric about renewable energy and its major investments in fossil fuels. In return, AGL launched legal action against Greenpeace. In particular, they kind of argued that Greenpeace's kind of campaign infringed its copyright and its trademarks. So rather than necessarily kind of debating and questioning the evidence that Greenpeace was putting forth, instead AGL went down a kind of a legal route of trying to say that the campaign being run by Greenpeace infringed copyright and trademarks, and they should be able to kind of get remedies. Unfortunately for AGL, the legal action had the kind of the equivalent impact of raising the profile of the campaign, making it much more visible, creating much more media attention about the report than it would otherwise previously had. So it was kind of a classic instance of the Streisand effect. So Barbara Streisand once kind of complained about her privacy being intruded in her particular house, and that led to a legal action and lots more attention being focused upon her particular place. And I think this dispute was a kind of an instance of the Streisand effect. So Greenpeace and its lawyers tried to kind of heighten the impact by doing lots of media and lots of commentary and lots of discussion about the conflict that was kind of taking place. And amongst other things, they kind of had these very kind of dramatic media protests on the steps of the Federal Court of Australia, with comments by David Ritter from Greenpeace, Glenn Walker, a campaigner, the General Counsel, Katrina Bullock, and Maurice Blackburn's principal lawyer, Rebecca Gilsonen. And essentially the defence for Greenpeace was that really their use of any copyright materials by AGL should be protected under the Defence of Fair Dealing in Australia. They maintained that because they weren't using the trademarks of AGL for the purposes of trade and commerce, they were not really infringing the trademarks of AGL. And moreover, they kind of highlighted that there were kind of larger questions about freedom of speech and public debate in this particular matter. And they were kind of concerned that copyright owners and trademark holders were really using their intellectual property rights in this case to suppress public speech and public discussion. So we'll just go through those various kind of arguments. In terms of copyright law really protects cultural creations. So literary works, artistic works, dramatic works, musical works, films, television broadcasts, computer programs. Copyright provides a set of economic rights, the right to reproduce the work, the right to communicate the work to the public. It also has various moral rights associated with it. So the right of attribution, the right to object to false attribution, the right of integrity. In this particular case, AGL was really kind of making arguments about economic rights. And they were focusing in particular upon the AGL logo and argued that that was a creative work, that was an artistic work. And the Judge Justice Burley of the Federal Court of Australia noted that Greenpeace did not contest that the AGL logo amounted to an artistic work. There have been disputes elsewhere about whether it's appropriate to protect logos under copyright law as opposed to trademark law. So there was a very kind of famous dispute about Exxon and whether or not that could be protected as copyright. And really the court was of the view that trademark law exists to deal with brands and logos. It's not appropriate to use copyright law in those circumstances. So the key question was really whether or not there was any defences, because the judge said, really Greenpeace had used the logo, so they reproduced the logo. So the critical question was, could they kind of invoke any defences? So in Australia, we have purpose-specific defences in relation to fair dealing. So you have to kind of get your conduct within one of these boxes for it to be considered a fair dealing. So there's criticism, review, research and study, reporting the news, use in judicial proceedings. Myself and many others have kind of pushed for a broad array of exceptions. And in 2006, we convinced the then Attorney General, Philip Ruddock, of all people, to recognise a defence of fair dealing for parody and satire. Apparently, Mr. Ruddock loves caricatures of himself and has a big collection. So for whatever reason, he agreed at that particular time with the Howard government that there should be a new exception for parody and satire. More recently, we have just added a new defence of fair dealing dealing with disability rights as part of our implementation of the Marrakesh Treaty. Australia does not have a general defence of fair use like the United States. So the United States has a very broad defence which lists a number of uses but is not limited to those uses. There have been a number of inquiries that have argued that Australia should also adopt a defence of fair use like the United States, but copyright industries have lobbied against those conclusions of various inquiries by the Australian Law Reform Commission and the Productivity Commission and the Copyright Law Review Committee and the Harper Review. But that is a little bit problematic for Australia because, amongst other things, one of the key functions of the defence of fair use in the United States is that it's designed to promote freedom of speech and freedom of expression. You know, in the United States language, copyright law is meant to be an engine of free expression. So there's sometimes been a debate about the way in which the defence of fair dealing in Australia has been interpreted, because sometimes it's been kind of interpreted quite narrowly. So as I was getting my coffee this morning from the coffee shop, they were playing the classic Men at Work song, Down Under. And famously, Larrikin Records sued EMI for copyright infringement over a little flute quotation in the Men at Work song of a Girl Guide song, Kookaburra Sits in the Old Gum Tree. And that was held to be a copyright infringement. And it was kind of a classic instance in which the existing defences of fair dealing didn't really properly protect what was happening culturally in terms of Men at Work doing kind of a homage or an allusion or quotation of that earlier work. More recently, we've had a really interesting precedent dealing with the defence of fair dealing for parody and satire, involving, of all people, Clive Palmer, another fossil fuel owner who had a political advertisement that was really very closely based upon a Twisted Sister song, We're Not Going to Take It. And the Federal Court of Australia held that there was copyright in the Twisted Sister song, there'd been infringement, and Clive Palmer wasn't engaging in parody or satire, he was just using it for political purposes. And the court said that in that particular case, there should be millions of dollars in terms of damages. So this particular dispute was a kind of an interesting one. And Justice Burley kind of considered both the question of fair dealing for parody and satire, but also really kind of explored whether or not the fair dealing for criticism and review was relevant as well. So he kind of went through all the various parts of the media campaign by Greenpeace. So for instance, generating pollution for generations, leaving a mess for the next generation, still Australia's biggest climate polluter, online banner advertisements, Australia's greatest liability, a parody website, an Instagram campaign, a Facebook campaign, a LinkedIn campaign, a Twitter campaign. they kind of the judge looked at placards, and the judge also kind of looked at what the activists were doing with the placards as well. So, the judge went into some detail about all the different parts of the media campaign. The judge kind of noted that certain activities were humorous. So, for instance, that one, the judge thought was a kind of example of parody and satire, but he was not necessarily kind of sure that some of the other placards necessarily had characteristics of parody or satire. And the judge kind of had some discussion about Greenpeace's accusations of greenwashing behaviour. But in the end, in the majority of cases, the judge was of the view that the defence of fair dealing could be invoked, either in terms of parody and satire, or for alternatively, the judge kind of considered the question about criticism review. So by and large, Greenpeace were successful, but there were certain instances in terms of their campaign that they had to change. So for instance, in their report, they kind of replaced an image of a campaigner with the actual logo, with a whiteboard with her writing in text her complaint about AGL without using the logo. So that was the first part of the case. I guess a kind of a mixed outcome. I think Greenpeace were kind of happy with the outcome of the dispute, but perhaps were a little bit kind of concerned by the very limited way in which the defence of fair dealing was being read. Perhaps it indicates that Greenpeace really needs to hire a professional comedian and humorist to ensure that their future work has the character of parody and satire. So I think that was kind of an interesting kind of element to it. But I think Greenpeace for a long time has been kind of concerned about larger questions about copyright law being used for the purposes of censorship. They have, for instance, kind of questioned copyright, site blocking and filtering laws like SOPA and PAPA in the United States. Australia has kind of passed kind of copyright filtering laws. So that was the kind of the first part of the case. And as I said, Greenpeace were largely happy with the outcome, if kind of concerned by the very fine nature of the reasoning. But obviously they did much better than, say, Clive Palmer, who was very much unsuccessful in trying to invoke the defence of fair dealing. But as a kind of copyright scholar, I'd be kind of concerned that, perhaps the law as it currently exists in Australia is still not really kind of grappling with kind of larger considerations about freedom of speech as it should do. Perhaps we need a broader defence like a defence of fair use. In addition to the copyright action, there was also a trademark action. And the judge in this particular case gave very short shrift to the trademark action. Burley kind of noted, in my view, consumers perceiving the online banner advertisements or the street posters would answer this question in the negative about whether or not, Greenpeace was using the mark in terms of the course of trade. The judge noted the use of the modified AGL logo is to identify that brand and the company that it represents as the subject of criticism. They had not perceived Greenpeace to be promoting or associating any goods or services by reference to that mark. Rather, it is the use of the modified AGL logo to refer in terms to AGL and the goods and services that AGL provides. So the judge held the consequence is that AGL's trademark infringement case fails at first hurdle. And the judge added that the trademark infringement action would also fail because AGL has not established that the use of the modified AGL logo is in relation to the registered services required by the Act. So in other words, just because you have a trademark over a particular term or logo or brand doesn't necessarily give you the power to monopolise all uses of that work. It's only in relation to certain classes of goods and services. So essentially the judge is saying Greenpeace is not using that trademark as part of trade and commerce. So you can't really kind of claim that there's an infringement in this particular case. So, you know, really the judge was very kind of critical of the approach taken by AGL. But I guess in relation to trademark law, there's no explicit defence for parody and satire like there is in relation to copyright law. So I think it's a bit problematic in relation to trademark law that there's not necessarily a well enumerated set of defences, exceptions and limitations. And in other jurisdictions, there's often been kind of conflicts over culture jamming of trademarks. So Adbusters, who came from Vancouver, have often been kind of engaged in co-opting trademarks and using them to as the subject of kind of criticism and ridicule. Naomi Klein, the Canadian journalist and climate activist, wrote a very famous book called No Logo. No Logo was very much about cultural activists trying to engage in jiu-jitsu against big brands by using their charisma and visibility against them to kind of engage in criticism about labour rights, their environmental standards, their other social practices. But really there's a whole range of other cultural activists who've been kind of engaged in such tactics and strategies. So in another kind of chapter that I'm writing for this book, I look at the yes men who like to engage in the identity correction. So they pretend to be from companies and organisations and government bodies and international organisations, and then do very funny speeches in the role of being imposters. Famously, they held a press conference and claimed to be from the United States Chamber of Commerce and issued a press release saying that they now believed in the need for decisive and meaningful climate action. And a real member of the US Chamber of Commerce kind of rushed into the press conference and denounced and said they're not really from the US Chamber of Commerce, whereas the yes men were saying, who are you? We've never met you. We are the real members of the US Chamber of Commerce. The Electronic Frontier Foundation had to assist the US Chamber of, or the yes men to ward off an action by the US Chamber of Commerce, who kind of claimed that there was copyright infringement and questions around trademarks and internet domain names. The Electronic Frontier Foundation kind of raised larger considerations about freedom of speech within the US system. Greenpeace has also had the odd other battle with trademark owners in the past. They ran a very funny campaign against Mattel, the toy manufacturer, over its packaging for its products, which they said was kind of came from rainforests and other places where they shouldn't really be kind of using such techniques. So they kind of ran a kind of campaign with Ken saying, Barbie, it's over. I don't date girls that are into deforestation. And that was actually a very kind of effective way of highlighting Mattel's environmental practices and the lack of sustainability about its products. Mattel, though, has often been quite litigious in terms of bringing action against all sorts of uses of Barbie and some of its other kind of toy products as well. But in this particular case, it led to Mattel changing some of its practices. So I guess that's kind of an interesting example.
Sorry, Matt, sorry to jump in.
Yeah, nearly time.
Yeah, so we're just starting to wind up, and just in case anyone has any questions, because yeah, so we've got a few minutes, 4 minutes.
Okay. So that was kind of a really interesting campaign. Greenpeace has also kind of used Star Wars and Darth Vader to highlight some of the problems with Volkswagen, and that was even before the diesel defeat device. So Volkswagen is kind of part of the dark side of the empire. And Greenpeace also had a bit of a run-in with Lego after it kind of complained about collaborations between Lego and Shell. And they kind of ran the campaign, "Everything is not awesome." I just want to kind of wrap up, I guess, by kind of talking about slap lawsuits and freedom of speech. I guess the kind of the larger issue to come out of this kind of conflict is that I guess it kind of raises questions about freedom of expression by individuals and activists and civil society organisations. Brian Walters for many years has been kind of concerned about the use of litigation against civil society groups and environmental activists, particularly in relation to defamation law. But I guess this dispute also highlights some of the issues around intellectual property rights being used in ways to try to curtail freedom of speech. I guess my criticism of the judgment is that it doesn't really necessarily engage with some of the history of the interactions between intellectual property and freedom of speech. As I said before, Lou Davis protested against the bicentennial and had a very important precedent about freedom of speech in terms of his imagery of 200 years of suppression and depression. There's also a kind of a case called Stevens versus Sony, and Justice Kirby in that particular case kind of highlighted the importance of the implied freedom of political communication. I think kind of raising my kind of final point, which would be really the dispute highlights the need for greater recognition of human rights in Australia. You know, at a state and territory level, we have some recognition of human rights in Victoria and Queensland and the Australian Capital Territory. At a federal level, we still don't have a proper Bill of Rights. Our Constitution has a very limited set of express rights, and it also has an implied freedom of political communication, but that has been increasingly read in quite limited ways by the High Court. So as Professor George Williams has said, that we really need to think about ways and means of reforming Australia's political system and constitutional system to ensure the respect for civil and political rights, particularly in relation to freedom of speech and freedom of expression. So I will finish at that point and we'll ask some questions. Rhiannon, did you want to curate the questions for me?
Absolutely. You probably only have time for, it's actually just hit 2:10, which is when the next session is supposed to start. But I could put your email address in the chat as well, in case perhaps anyone wants to email you any questions. But were there any questions from people in the room? So what I might do is I'll put your email address, I've got that right here, and I'll put that in the chat for people. Yeah, thank you so much. That was really fascinating, and especially the work that I do, very, very relevant. And like you say, we need to make sure that those rights are protected so that activists can do the work that we do and yeah, take on these big corporations. So thanks so much, Matthew Rimmer, and everyone, big round of applause. And yeah,
hopefully my talk will smoothly slide into the next session, which is looking at greenwashing and corporate control.